We are sorry for some delay. Yes. Some motion matter. Okay. But ensure that advanced copies are given to the other side. 6. Okay. Item 6. Password for the day is paid for by learned counsel for the petitioner. Use say for both sides are represented. Huh? Please repeat again. Please put on your speaker. Is it on? Yes.
Review petition, my lord. Review has been prepared, my lord. The petition was filed on 9th of this month, my lord. And the petitioner is in detention camp, my lord. And his deportation is being initiated, my lord, and likely to be deported.
Ensure that copies are given to them.
Yes, my lord. Today is.
May I please? So back to mention for item number 7, your lordship. That pass off for adjournment, your lordship, after view vacation, my lord, 2025 later.
Okay. Same order. Password for the day.
Master bless.
This is. First, by back to the reputation which was last listed on 17 admission item number 26 by them, but it was not reached. While the petitioner says that there is no any application is pending or he has not got any notice, but he was arrested on.
There were so many days. Today you are
My
making a
lord-
mention.
My lord, kindly may allow to unlisted matter the matter on 2 p.m. my lord, just for instruction to know whether any case is pending or not. During the vacation period, he may take some process in the tribunal. At least get the certified copy.
You do one thing. Instead of getting it listed, you give the name. Mr. Payang is there. You give the names.
My lord.
Let it come in the reopening. You will get the instructions. You give the name and particulars to Mr. Payang.
My-
We have full faith. He will give us the information on wide open.
Oh,
With due respect, Lordship, I beg to mention item number 5 for adjournment. As my senior is out of station.
No, there is an office note here. Please wait for your turn when the matter is called. There's some office note. We have not checked it.
May I plead your honor? I beg to mention item number 8. Your honor, my senior, Mr. Pierali Ahmed, is on leave and he's out of station. So kindly, your honor, take the matter after vacation.
Okay, password of the day is paid for. Same. Okay.
Thank you, your honor.
Daily list, item 1 with 2 for motion.
May I please, your lord. In both the cases, my lord, LCO was called for, it has received ballot. And may I pray that it may come up for vacation for admission.
Okay. Heard Mr. S. Biswas, learned counsel for the petitioner and so for the respondents. Next, pursuant to orders passed earlier, the records of the tribunal is received, which is required to be examined accordingly. What is inclined to issue any returnable forthwith without requiring any fresh steps to be taken as the record is taken to stop. This is the matter for hearing in the week commencing 9/2/2020. 9/2/2026.
Item 3 for motion.
Item 1 and 2. Pass separate notice.
May I please, your lordship? My lord, in this case, my lord, the petitioner is in bail, my lord. And the TCR has already been received.
This also we issue rule and fix it for hearing. Same order. Mr. S. A. Ahmed and counsel for the petitioner. And so also for the respondents. Pursuant to order passed earlier, the records of the tribunal is received. Court is inclined to issue, which is required to be examined. So court is inclined to issue rule reasonable forthwith without requiring any steps to be taken. This is the matter for hearing in the week commencing 9/2/2026.
Obliged.
Item 4 for motion.
Madam, show motor contempt, my lord, that notice be issued, my lord, because giving false information to the court, my lord, deliberately. That is the finding.
But Mr. T.J. Mahathir and senior counsel, assisted by Mr.
T. Gogoi.
T.
Gogoi.
Gogoi, learned counsel. Next para. Mahathir, please come to page 86.
My lord,
Please come to page 86.
it is, yes, my lord, I have seen that.
Ah.
The
Should I-
appeal has been dismissed.
Should I take it up? For initiation of contempt? Or it should go,
Because there is judgment, yes, that
No,
is
I'm
the
a
direction
party
passed
to
by
that.
your lordship. Correct, my lord, that I, sorry, that is not the notice, my lord. Yes, that is judgment passed by your lordship. So that
was-
order,
I was a member of the bench.
my lord.
uh, As one of us in the bench within bracket, K.R. Suranaji. Was a member of the bench. Should pass the order dated 21/11/2025. It is deemed appropriate that a bench without one of us within the K.R. Suranaji. That this matter be placed before another bench without one of us, K.R. Suranaji.
My lord. Deep look.
But what do you think of it? I have not examined it. In fact,
Actually,
I could
original
no,
order
no.
was passed by Honorable Justice Bujal Borua.
Ah,
Then, my lord, same was endorsed by your lordship in the
so
final
that's why I
judgment.
should.
That I have seen, my lord. Deep lord.
Supplementary item 10 for motion.
Yes.
Made lordship, in this case, I couldn't take the instruction, lordship. Sometimes required, lordship. But otherwise, I may be allowed to rest representation, the border department of Home and Political Department.
Pardon me.
Otherwise, I may be allowed to file a fresh application representation to the Department of Border Home and Political Department.
We give you liberty if you want to do anything. We keep it alive for the time being.
My lord, in fact, my lord, my learned friend was asked to get the instruction where he has filed his petition. He could not get it, my lord.
We understand that.
Yes.
But you see, once he's there and Mr. Suleiman is.
Yes.
has
If this
filed
case is pending, no, my lord, no, there will be no deportation, definitely. Otherwise, my lord, we are initiating the deportation process. That's why they are coming, my lord.
We understand.
Yes. Is this petition is pending, let it be pending, my lord. In the meantime, whatever he can do. Otherwise, my lord.
We understand. Otherwise, it'll be in difficulty once. We fix it on the reopening day, 5th of
Yes.
January.
Let him get the instruction.
Both sides are represented on the prayer made by Mr. James Suleiman and counsel for the petition. List on 5/1/2026.
1, 2,
5/1/2026.
1, 5.
2026. By the time you get instructions, otherwise.
Item 11 for motion.
Mr. Suleiman, today is the last day. We don't want to.
Yes.
Today is the last day. We don't want to disappoint you.
11.
Well, my learned friend is saying, my lord, otherwise next day will be the first day. So let it be on 6th.
Okay, good. Good. That's what nice thinking. Okay, 6th, make it 6th. Okay. Today we must end on a happy note.
Yes, ma'am.
Yes,
My lord, the petitioner is taken into custody, my lord. Earlier also, one of the
but,
petitioner.
but you. But this is an opinion of 2018.
18. Thereafter, he was arrested and remained 2 years time during COVID period. And he was released out under impression that he has been acquitted. So no case is required. That was his illiterate person. This was his my lord, impression. So my lord, suddenly he is arrested again, my lord. So the petitioner is before your lordship, my lord. Lordship may examine the mail.
No, we have examined it. That is why we know 2018. This matter also we take it up on 18th, on Tuesday,
7.
on 6th or 7th.
7. Other matter is fixed on 7.
Both sides are represented on the prayer made by Mr. A. Adil and counsel for the petitioner. This is the matter on 7/1/2026. Because 2018 will, otherwise we are not convinced. The explanation
my-
rendered not convinced. Today being the last day, we don't want to disappoint anyone.
We're getting it.
12, okay. 12 is also same arrested.
Hmm?
Same matter, 12, my lord.
12 also same.
Same.
only.
Obligors.
May it please, your lordship.
Yes,
This is a contested case, your lordship.
2020.
Lordship.
You want us to pass orders today or you will leave it on 7th?
In the meantime, records may be called.
No, because 2020, your explanation given, we are not satisfied.
This is a completely an illiterate lady, your lordship, and
No, you take, what you call, take some good advice from Mr. Pang, if he can help you, otherwise to 2020, we can't. He may give you a roadmap. You may speak to him, he can give you a roadmap.
Lordship.
7th?
7.
Okay, same order.
oblige, lordship.
Supply item 14 for motion.
I am within time. At page 24.
Page
24.
24. Mr. D.K. Agarwal, counsel for the petitioner, and so for the respondents. Page 24. Opinion dated 16/9/2025. Asked by so-and-so in case number so-and-so, IMDT reference number so-and-so, thereby declaring the petitioner to be a foreigner of post 25 to 1971 stream. Notice returnable in 4 weeks, extra copy within today, in course of the day. Call for the records to the following email address of the learned tribunal. Next, the prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection made in the writ petition, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Board of Barbeta. If there is one email address, say address, and then if there are two addresses. No?
Much obliged.
List after the 4 weeks of receipt of records.
Item 5 for admission.
Both sides are represented. Next, the learned counsel for the petitioner had paid for an adjournment. Next, on a perusal of the office note dated 24/11/2025, it appears that the records, the tribunal's records is tagged with the record of WPC 4545 of 2018. Next, accordingly, comma, on the next date of listing, tag the records of WPC 4545 of 2018. Next para. List on 9 January 2026.
Item 9 for hearing.
This side. Where is the petition? We have filed an application for vacating of the order. Hearing also number of times it has come up for the court, the chief justice also, but some of the matters were taken up because the Chaudhary was there. So it was assigned to other bench. Accordingly, it has come. It is vacated on the file of 30/12/2022.
Yes, it is available.
That's it.
This is your application.
My application.
And what is the interim order you wanted to?
The interim order to vacate because there's the interim order which has been passed by this court. The lordship looks into,
It's only a order of status quo.
but the industry is totally shut down. We couldn't do anything because by virtue of the interim order. Status quo which was passed. Somewhere on 11/5, not 11/5. And our consent to establish was granted by the authority concerned in the year 2020.
But it's a red category industry.
Consent to establish for running an industry, it was granted in 2022. 2023, there was an interim order which was, and this NOC has come up before this court. So our first objection before looking into it that what is the locus of this the petition? New opportunity for children. That's the first point which we have raised. What is this locus?
No, because now when we see Delhi, now we find that locus is something which can't question now. The position in Delhi right now, where people can't even look what you call the vision, and the AOQ has come down to a very worst level.
That's true. But please look into it here. First point you are watching is decide regarding about the locus. Why not the documents, these are PIL.
Yes, we have no option, but we'll have to hear it because there is judicial order to take up the matter for hearing.
Lordship. Lordship. Lordship, my senior is on legs in court number 1, your lordship. That is a different. Lordship can take it on first week of January, your lordship, as soon as it reopens.
No, because he's on the, if there is a status quo which is affecting him. Have to take it.
Lordship, as on that, it's still not established, your lordship.
No, whatever maybe you have.
They have not started manufacturing, lordship.
No, better.
No, not that. You see, whatever is happening, but the fact remains that there's an application for this interim relief. Here, there is a judicial order that the final hearing be taken up.
Okay.
And if, what do you call, if we can't take up the final hearing, then interim order will have to visit. We have no choice.
Lordship, may I pray after some time, then lordship.
Okay.
You can get John's interim to have one.
Before your lordship takes up, we have given a note to your lordship.
Yes.
Because I have filed an application for vacating of the stay order. And a note which has been given, please look into that note. We have locus of the petitioner is being put to challenge. This is very serious. Certain documents, they got certain document. What is the source of the document? Your lordship, what is the PI? What is the source of document? Neither you made an RTL, and you got my document and document of one sham carbon, how you got it? Under
No, but that would not be a relevant question. The reason is that assuming that the document is a stolen document, let us say that he made an unauthorized entry into your premises, or the government's office, and these documents were stolen. But if it is relevant for the purposes of PIL, we can't shut our eyes out.
No, my lord, the problem is not there. There is a Guwahati High Court rules. PIL, your lordship knows that 10(1)(c) of the Guwahati High Court rule, please look into that rules, my lord. 10(1)(c). Okay.
Yes, public interest litigation rules.
Yes,
Yes.
10(1)(c). Give it to him now. Why yours? My lord, see at 490, my lord, I think this is your lordship is holding this,
Yes.
490. See 490, filing of PILs. Right, correct,
Which document you are referring to?
yes.
Which document you are referring to?
Yes.
Here?
Document which you are referring is in the note, it is mentioned, my lord. Kindly see B, my lord, in the note.
No, which is the document?
Yes, I'll
Which?
just tell you. Page 131 of the PIL. 131.
Yes.
Kindly see, this is given to one Messrs. Sham Carbon LLP, 27th of January 2022. They refers in the PIL that this is what was given and that was cancelled. Approval which was given could not be accorded. And how it will be accorded to you? See, my lord, 27th of January 2022. With reference, it is to inform as per a board notification, setting up a new calcium petroleum coke industry is not allowed within the state of Assam. For your, therefore, your request for approval for setting up CPC units would not be accorded with you. This is one as carbon. Now, if you see my application at page 133,
কি মূল্য স্যার?
না বেলেগ একো নাই সেটা ফোকাসও চ্যালেঞ্জ করি আছে
133, my dear. This is the application which I applied.
Lord, I am the petitioner, can I start?
Yes.
Yes.
Mr. Das is questioning your locus standi.
Yes.
That's why we.
Lord, this aspect of the matter was gone into at the time of admission. And when the interim order was passed, all these aspects were considered. Thereafter, my lord, interim order was passed. Now, my lord, this industry is in a red category industry. If your lordship would kindly come to the facts of the case, my lord, the guidelines on which we are relying is at page number 120A. We are seeking enforcement of this office memorandum issued by the Government of India. In exercise of the power conferred by subsection 1 and 2 of section 3 of the Environment Protection Act, the central government hereby issues the following guidelines for regulation and monitoring of imported pet coke in India. Guidelines. As per the notification of the Director General of Foreign Trade dated 17/8/18, import of pet coke for use as a fuel is prohibited. However, import of pet coke is allowed for the following industries, namely cement, lime kiln, calcium carbonate, as in the instant case, and gasification for use as feedstock. Pet coke importing industry, namely, we are concerned with calcium carbonate, and gasification shall obtain consent of and registration so and so, so and so. So, my lord, other than use in these following industries, import has been banned by Government of India. Then, my lord, will kindly come to page number 10, page number 130.
Just a moment.
My lord, will kindly come to page 130.
Just give me 10 minutes, just.
Due to pollution level caused by calcined petroleum coke and low as metallurgical coke industries in the surrounding areas, it has been decided not to allow any further expansion of the existing as well as new calcined petroleum coke and low as metallurgical coke industry within the state of Assam. Page 130, my lord.
130.
Yes, 130. Pollution Control Board of Assam has banned setting up of new unit which, my lord, produces coke. Due to the pollution level caused by calcined petroleum coke and low ash metallurgical coke industries in the surrounding areas, it has been decided not to allow any further expansion of the existing as well as new calcined petroleum coke. So there will be no expansion of the existing unit and no new unit can be set up. Then, my lord,
Just a moment.
I'm sorry, my lord.
Yes.
Yes. My lord, based on the decision at page 130, another carbon unit, when they applied for establishment of a new unit, it was refused which your lordships will get at page 131. To show, my lord, how they are taking double standard. This was on 27th of January 22. Kindly see it is addressed to one Shyam Carbon. With reference to the above subject, it is to inform you that as per board's notification dated 17th of February 2018, that is the previous page, setting up any new calcined petroleum coke industry is not allowed within the state of Assam. Therefore, your request for approval for setting up of a new CPC unit could not be accorded with. So, my lord, having regard to the decision contained in page 130, my lord, this request of this particular party was refused. Then, my lord, will kindly come to page number 140. Now kindly mark the date, my lord. It was on 10/12/2012. Now this is an order which was issued by the Pollution Control Board in favor of the private respondent, my lord. Provisional consent to establish is hereby granted to Messrs. Carbon Product India for their expansion of calcination unit with production capacity of 12,000 metric ton per annum located at so and so, as amended under the following terms and conditions. Now, from this order of consent to establish dated 10/12/12, my lord, what is evident is that a permission was given to the private respondent for expansion of their unit. Now, if your lordships will kindly come to page 141, column number 17, my lord. The consent to establish will be I'm sorry.
Yes, 141,
My lord,
After that.
serial number, clause 17, my lord.
17.
Yes. The consent to establish will be valid for 1 year from the date of issue of the order. That means the consent to establish, which was given on 10/12/12, my lord, it will be valid for a period of 1 year. That means it will expire on 9/12/13. Now, my lord, will kindly come to page 133. Now kindly mark this number, my lord, application number 474359. It is dated
Page number?
24th of March 21,
Mr. Chaudhary, page number?
133, my lord.
It's only that one.
Yes.
My lord, this is dated 24th of March 2021. The date will be noticed at page 139. Kindly see, my lord, it is filed by one Madhurja Bora, Director, 24/3/21, at page 139. On left-hand side, middle portion, my lord, the date. Now kindly come to the content at page 133.
Read.
Hey, Mati se Mati.
Read.
Now kindly come to page 133, my lord. On top, we hereby apply for consent to establish under section 25 and 26 of the Water Act and section 21 of the Air Act. These are all part of life. Okay. acha. Anyway, my lord, this is an application seeking consent to establish. Am I clear, my lord? Under section 25 and 26 of the Water Act and section 21 of the Air Act. Now, very interestingly, now Lordship will kindly come to page number 143. This is on December 2022. Now, kindly see the Miller subject. Extension of consent to establish. Reference. Consent to establish issued by board wide letter dated 10/12/12, which I have already shown, which had lapsed on 9/12/13. Then application number 474359. Now I have already demonstrated, my lord, this is not an application seeking extension of CT validity, but an application seeking fresh CT, consent to establish. With reference to the above subject, Pollution Control Board hereby extends the validity period of consent to establish as referred above for a period of 5 years with effect from the date of issue of this order, the detail of the project, etc. Now, my lord, what they are construing to be and consent to establish which was issued to them, which your lordships will get at page number 133. Now, what the authority have done, my lord, despite the ban, they have extended this, whether they could have, that is the cracks on merit, my lord. I'll satisfy your lordships on my locus part also, because this aspect of the matter was gone into. Now, kindly see at 133, consent to established. Now, kindly come to, my lord, page number, sorry, my lord. Confusion. Sorry, Miller, I sorry, referred to wrong page. Please come to 140. Now, they have purportedly extended this by 5 years. Now, kindly see, Miller, provisional consent to establish hereby given to MM Carbon for their expansion. Now, please come to page 141. consent to establish will be valid for 1 year from the date of issue of the order. That means this order lost its efficacy on 9/12/2013. Now, what could not have been done directly, could it have been done indirectly, madam? That is the issue. Now, there is a principal, decision of the Pollution Control Board Assam that they will not allow expansion of an existing unit and they will not permit new unit. Now, what they purport to do, they purport to extend this. Its validity is already gone on 9/12/13. So what you could not have done directly, you cannot do indirectly. This is the case, Miller. Now, these matters are of utmost importance, Miller. Today, the country is facing the heat, Miller. Lots of everybody knows in Delhi what is happening. In today's newspaper, we have read one news item as far as Guwahati is concerned, Miller. Now, this how to treat this waste that is generated, the existing capacity is only 33% of the waste generated. That's why it is said, Miller, that is one of the factors which is contributing towards pollution in the Guwahati city also. So these are matters needs to be now when Pollution Control Board, having regard to the office memorandum issued by the Government of India, had taken a policy decision that they will not permit any new unit to set up, as well as they will not permit any expansion of the existing unit, whether this could have been done. Now, this is the case, Miller. There is a clear-cut restriction. Now, in spite of that, they have given it. Now, my lord, as far as the order of this honorable court is concerned, my lord, if your lordship would kindly come to page number 326. No. Am I entering order to make it? Last of the select. If your lordship would kindly come to the interim order which was passed. Yes, please come to the interim order which was passed on the very first day, Milord, at page number 11/5/23. Milord. Yes.
Yes.
The petitioners filed the instant writ petition in the nature of
This
public
we have gone
interest.
into. This we have seen.
Yes.
Status quo is granted.
No, not only the reason, Milord.
Okay.
Kindly come to Milord, the second para.
Yes.
Sri Chaudhary, representing petitioner, drew court's attention to the notification issued by the Pollution Control Board indicating that it has been decided not to allow any further expansion of the existing CPC unit as well as setting up of new CPC industry within the state. However, the existing CPC industries have been allowed to run their business with all pollution control devices which are to meet the standard as stipulated by the Pollution Board Assam. Attention of the court is also drawn to the communication dated 27/1/22 issued by the Pollution Control Board whereby a similar application submitted by Shyam Carbon LLP Guwahati seeking approval to set up new CPC industry was rejected. It is further submitted by Sri so that the respondent 4 applied for setting up a CPC unit in the year 2012 and consent was granted by later dated so which was valid for a period of 1 year only as per clause 17 of later dated 10/12/12. Petitioner has alleged that after receiving consent for setting up CPC industry in 2012, no further action was taken by respondent number 4 in pursuance of this consent letter. And thus, according to the petitioner, the validity of the consent expired after 1 year. The respondent number 4 thereafter filed a fresh application bearing so for grant of consent to establish a CPC unit at Amingao. The said application has been treated by the Pollution Control Board as a prayer for extension of consent given to respondent number 4 in the year 2012 and by later dated 31/12/22, consent has been granted by the Pollution Control Board Assam to the respondent number 4 to set up a CPC unit Amingaon, which is under challenge in this PL. We are of the prima facie opinion that matter requires further consideration because Pollution Control Board, once having taken a decision not to allow establishment of red category industry in Assam from 70 to 18, cannot be allowed to change its stand at this stage. So, my lord, this was the reason which was taken note of by this division bench of this honorable court, my lord, while granting the interim order. Now, my humble submission therefore is, my lord, it's an open and shut case where the Pollution Control Board, my lord, instead of giving effect to its own policy decision, is trying to, my lord, deviate from it. My lord, the policy says be it extension of the existing capacity or setting up of a new unit. Both are, my lord, barred. Assuming, my lord, their 10, 12 order is still alive, even then it cannot be done. So therefore, my lord,
Please come to the affidavit at page 521.
yes,
Please turn over to page 523.
521, my lord.
Yes, 521.
Yes. Additional affidavit, yes,
Yes. Now you see what has happened here.
yes.
Now here they are referring to accordingly the consent paragraph 2,
Yes.
page 520.
That this affidavit is filed for the limited purpose of bringing on record certain document pertaining to electrode carbon paste, a unit of respondent number 4 located in Amingaon, which has been brought into issue on the last date of hearing. Accordingly, the consent to establish no objection dated issued by pollution bearing so and so to
This is
respondent of for
2006 now.
setting up.
Now this is 2006 and it refers to electrode carbon.
Yes,
Electrode carbon and we don't know the difference between electrode carbon and calcinated coke.
yes.
So is it a shift in the business or it is a separate unit because 2006 reference has been made? Huh?
Electrode carbon based unit is a separate.
So why this is clubbed here? Because
But that on that they court wanted to know the date of hearing, whether the electrode, whether the CPC unit is an extension of the earlier unit.
Okay.
To bring on record, because in 2012, the word extension has been inadvertently added. Clarify that portion. The electrode carbon based
it's a
unit
different unit.
is a separate unit. We are still having that and timely renewal.
এখন কোনে help করেছে?
Clarify that aspect.
So at times when you read without your assistance, this happens. Because you couldn't understand it. It's 2006.
No, my lord, my argument is very simple. The office memorandum of 2018, it prevents both, either expansion or setting up of a new unit. Now, they want to give the color of an expansion of an existing unit. Even that is banned. So until and unless you revise your policy, where is the scope of my lord giving that permission? That's the only point, my lord. It boils down to that only.
And so Das raised the issue, which
Yes.
are not there.
Now regarding locus, my lord,
No,
yes,
like Lucas and even the document which you are referring to, that Shyam promotions, the Shyam Pope.
yes.
He says that this was never marked to you, so how do you get this document? And that is why you're.
No, my lord,
One of
that is a document which is not in dispute. All that we are trying to show, my lord, that similar requests of other parties were rejected. That is only that, nothing beyond that, my lord. That means Pollution Control Board is taking stand which is inconsistent. In case of some parties, they say it can be done because of 7/20/18, whereas in the present case, they have deviated from their, my lord, about stand. Now, my lord, as far as our locus is concerned, we have explained, my lord, in our writ petition, my lord, para 2, 3, and 5. And these aspects were gone into at the very beginning, my lord, after a hot contest, that order was passed. At page number 7. That at the very outset, page 7 of the writ petition.
Just a moment, in the context of what you were submitting, we'll come to this locus standi a minute later.
Yes,
You see, if you will come to page 431,
431, my lord. 1 second. Yes,
No, this is an part of the affidavit filed by respondent numbers 2 and 3.
Yes.
Now, here they are trying to say in paragraph 6 that it was a one-time exercise. What was that? We fail to understand. Because I'm reading it out of context, so therefore I don't know in what context this has come. Now this, then there you will find subparagraph A to
That's it. Yeah.
this others. So they are trying to say from here,
That because of the order dated passed in 3726, it was considered.
this one and then the second.
No, they say, Milord, respondent number 4 application has been considered in view of intervention of this honorable court in WPC number so and so.
Yes.
So now let us see the order, Milord.
No, we'll read this in context and then come to your reply.
Yes,
Page 432.
yeah,
Now they say that this notification of 2018
Yes.
was superseded by this notification of 5/4/2019.
yes,
And then again, they said that the renewal was done as for this application of 12/3/2019. This
Yes.
is how they are proceeding.
now we have
So how-
replied, we have dealt with this, Milord. I'm coming to that.
How does this
Yes, 435. to
affect
435.
your submissions?
Yes, I'll do my submission, Milord. 435 to some.
And then they take another stand here. Mr. Chaudhary,
Milord,
they take another stand here.
yes,
They are now trying to distinguish between what you call imported pet coke. And they are trying to distinguish between an imported pet coke. And then they are trying to say here, this CP at 432. This stand you'll have to clarify because we have not been able to understand this. When we read along this volume, we can't
okay.
really understand. 432 paragraph E.
One second. আমার এগুলোই তো কোড করলি আমি। ওর এখনো রিপ্লাই তো 430
Your reply is at page 435.
That is what I'm not getting, Milord.
Page 435.
Yes, 435, I'm not getting that. 435 কোনে নাই দেখুন।
Can we give you our copy?
I got it, Milord. I'm sorry for that.
No, it's okay.
Milord will kindly come to paragraph number page 437. Para 5. That with
In fact,
regard,
Mr. Chaudhary, I'll tell you, even to Mr. Saikia, what has happened, this was so voluminous now with all these pleadings that if we read one part, we tend to forget what was the context in which we were reading.
Milord, to be honest, I didn't come that prepared today. I thought, Milord, today is the last day. Maybe the matter will not be
No,
taken.
because the interim order was pressed, therefore we
Yes.
had no choice but to start hearing.
Yes.
But the problem we are finding is, I'm being very honest with you, we don't get so much of time to read.
Milord, can I make
the
one
day's
prayer,
work.
Milord? Lordship may keep it as part heard. Can
No,
it
part
come
heard
up
will
on
not
the
keep.
reopening day, Milord?
Parted will not keep, but what we are trying to tell you, both of you,
Yes,
scientists, including Mr. Mr. Barba, is that since we are reading so many affidavits, there are about
Quite a few, Milord.
not quite.
Eventually, it runs
Yeah.
to 500 and odd pages.
We have made a list of it. We have 12 affidavits, including the writ petition. So by the time we are reading one part, we tend
Tend to forget what we read.
what context we were reading. So it's really what you call, we've not been able to
Index penalty.
follow it.
If
You
Lordship
can give
wants-
us a note.
Get the index, we can prepare that index during the vacation and submit that index.
Yes.
That's-
Even a bullet point note, because.
Yes,
um,
in that
What
index. it will
what
be bullet
we'll do,
point.
Milord, from our perspective, well, in 3-4 pages, we'll cover everything.
Please.
Yes,
because,
we'll do that.
Because we are, in
No,
fact,
no, sorry. No,
honestly, we are telling you.
no, in fact, to be honest, Milord, under the Guwahati High Court rules, there is a prescription of supplying a Milord list
That's
of
okay.
dates.
You see, when we can understand, it's no point.
If it is a
Probably-
small one, yes.
This we have really had.
We'll do that, Milord. We'll come up with that, Milord, compilation. short
So
compilation.
that, Mr.
Yes,
Thakia,
Lordship, we'll do that.
please, both of you are here and both of you are extremely busy. Please tell us the date when you want us to be, matter to be listed.
27, 28.
8th of January, Lordship.
Yes,
8th of
8th of
January.
January.
Special bench, is it? Like,
Rupam Kumar. Yes.
Mr. K. N. Chaudhary, Lanet Senior Counsel. Comma, Mr. Senior Counsel assisted by Mr. Mr. Gautam, and Gautam, I'm sorry. And Gautam Lanet, Counsel for the petitioner, comma, Mr. D. Saikal, Lanet, Advocate General, assisted by Mr. You there, Mr. S. Barua, Lanet Standing Counsel for the PCB. And Mr. D. Das, Lanet Senior Counsel, assisted by Mr. T. Chakravarti, Lanet Counsel. Stop, as the pleadings are voluminous, comma, the court is of the view that a short bullet point of submissions be, along with the list of dates, be provided to the court. Next para, accordingly, matter stands adjourned today. List on 8/1/2026.
The interim order will continue till.
Okay. Interim order past year stands extended till the next date of listing. Next para. If it is just a moment, it is made clear that if for some reason the matter cannot be heard, comma, the application for vacating of the interim order shall be taken up.
Yes.
We are sorry, yesterday we couldn't devote so much of time. We wanted to read it and make it through,
But
but
it's okay. End of the year.
end of the year, and wish you all a good
We also.
vacation and
Mr.
a
Lordship
very happy new
something
year. To everyone present. We are
Obliged, Lordship.
Production list, item 1, Khudeja Khatun versus Union of India.
which page is the opinion? 49.
The order dated 11 December 2025, Your Lordship.
We'll give bail in this matter.
In filing, Your Lordship, additional query, visitation right may be granted to the family members, Your Lordship. He is a cardiac patient, Your Lordship. To provide medicine at least. Otherwise, he will not survive, Your Lordship. Bill.
She is where?
He is in Goalpara, Mattia, Your Lordship.
What? Wait for the details inside. Advis G. Varan and counsel for the petitioner and so for the respondents. Challenging the opinion dated 11/12/2025. Passed by so-and-so in FT case number so-and-so, SP reference case number so-and-so, thereby declaring the petitioner to be a prisoner of post 25/3/1971 stream. Notice returnable in 4 weeks, extra copies in course of the day. Ms. Vara, in course of the day, you will have to give copies.
Lordship.
In course of the day, you will have to give them copies.
Lordship.
In course of the day. Copy of the records to the following email address of the land court tribunal. Where list on so and so receipt of 4 weeks or in receipt of the policy. Is an IA But so and so. The learned counsel for the applicant has submitted that the applicant is the petitioner in the connected WBC 7460/2025. I will come up wherein the opinion dated 11/12/2025 passed in so and so has been assailed. Next, it is submitted that the applicant has been applicant namely so and so has been taken into custody on when
11 December. sir.
same day
Same day.
on 11/12/2025. The day the opinion was pronounced, and she has currently been lodged at the transit camp Matia Gwalpara. Oh, sorry, temporary jail Matia
Temporary.
Gwalpara. According, she is paid for bail. Next, the prayer for bail and release from the detentions, from the transit camp is opposed by the learned standing counsel for the empty matters. Next, considering the projection made in the connected rate petition. Bail of ₹1,000 for the family members within 3 days. The Superintendent of Police border, which place?
No.
No, Lordship.
Nagaon.
No.
The next step to have the petitioner released from petitioner which was released from the transit by Matia Gwalpara. As a condition of bail, the petitioner is directed to appear before the Superintendent of Police border
No.
Nagaon.
No.
Once a month. Till further orders. That she will not leave the territorial jurisdiction of the said authority without prior intimation in writing. Next para. If the appropriate conditions are added, it will be open to the responding authorities to case for cancellation of bail. Next para, list on, sorry, this application stands disposed of.
No, sir.
Production item 2 for orders. Abdul Rahim versus Union of India.
Oh, there is a caveat also.
No.
The item number 1, caveat is no. यदि caveat লেখা আছে
No, I don't.
यदि constitution লেখা আছে caveat
The caveat number will লিখা আছে in blank আছে স্যার।
okay.
In the review petition, there is some delay, 1850 degree.
What's the period for review? Where is the order under for which review is paid for?
My lord, in the IA, it is annexure number AML, page number 10.
It's an 18 review. You should have a very strong ground.
Lordship. Yes, I'm going to delay by not my lord, review.
Grounds.
That's in the review petition, we have taken down of review order, that my lord. And there are some documents were not produced before this time. Good, my lord, at the time of.
Just a moment. 2018, we are 6 years, sorry, 7 years. You're not inclined to entertain.
Lordship, he was in custody when the petition was filed, my lord. Thereafter, my lord, in the year of 2020, he was released in view of the Honorable Supreme Court's order, my lord. And in the release order, my lord, that is annexed as annexed B in the I, my lord. The Superintendent of Police, Nagaon, my lord, has released him on bail of rupees 5,000, my lord, and directed him to appear regularly before the concerned police station, the IO of Roha Police Station. He was regularly appearing before my lord, concerned IO. And and he was under impression that since he has been.
So when he was regularly appearing before the police, he did not read the opinion. Now, once again, he is taken into custody. He's taken into custody.
Yes, ma'am.
Now he has, in the jail, he has read the opinion and found out that review can be maintained.
My lord. Worship. They are laymen, my lord. They can, moreover, my lord, they are financially very, belongs to very backward class, my lord. Therefore, my lord,
You
they
don't tell
cannot
me.
even-
You know your reputation outside. You have very good reputation outside. One of the very premium lawyers taking very high fees.
No, lordship, but my lord, no, for poor person, my lord, 100 rupees is very hard to. Lordship. No, lordship. We are always dealing with the cases of the poor people's mail with very minimum fees, my lord. Lordship, that is, my lord. Humor may be, my lord. Lordship, may I please, lordship, can we come to an excerpt 28 of my lord review. In a similar nature of case, my lord, one petitioner approached the Honorable Supreme Court, my lord. Case number 132, my lord. That is the order of 2019, my lord. 17/6/2009. No, my lord, not my lord. Obtain the order from online. My lord, that is my lord. No, my lord, Abdul Rahim. My lord, in page number, my lord, 112 onwards, my lord. Yes, my lord. Copy of notice, my lord. This is no specific, my lord. Period is mentioned above. This one is there. Now, next question, my lord. I'll give the report. My lord, it is totally blank, my lord. No string has been mentioned, my lord, and no materials has been collected against him. Because the proceeding itself is ab initio illegal, not maintainable. And subsequent order also is not order.
Two four five of Lordship judgment,
Yes, sir.
245 of 2019. To Kurjan Nesta.
Yes, yes.
Just. WBC 245 of 2019. Date of opinion, date of judgment 28 to 2025.
The initial order aspect initial order or aspect order was passed for non-independent. We have could not highly establish function. Something which we are not the actually by the
But appreciates everything, madam. Everything.
Was in their custody at that time, but his family member had captured that for unbailment. That's someone else has managed. Moreover, otherwise, Lordship, otherwise, my lord, that case was dismissed in the year of 2018. Thereafter, he remained in custody for about 2 years, my lord. Only for financially backward, my lord. Otherwise, he would have come to the Supreme Court, my lord. My lord, that is, my lord, it can be assumed, my lord, that having financially a stronger position, my lord, he would not remain silent, my lord, and stay in custody and for another 2 years. My lord. Yes, my lord. My lord, before that, my lord, in my name, my lord, the land has been mutated from my father. And that is there, my lord. And voter list, my lord. Yes, my lord. 128, my lord. 28 and 30 is also there, my lord. 30 is, my lord. Um, Single name is there, my lord, and next space, my lord, the particular is there. That will apply for certificate to, my lord, only one name is given me in certificate to. You have more time to obtain another certificate. Yes, but. And next is, my lord. Serial number is Bazu Sheikh, Zaiful Nisa, Abdul Rahim, Arif. This is my lord, the voter list of 1989.
Yes, my lord, at this, my lord, I may pray for dismissal of this, my lord, because it's 1,850 days in delay. My lord, in filing preferring the review. And it is not that, my lord, he didn't know anything. Even in the, my lord, there, my lord, second issue, my lord, it is admitted position, my lord, they have submitted a false document before the tribunal, and that was considered by this honorable court also, while in the writ petition. And that there is no explanation, my lord, to that effect. Now, my lord, review after my lord, this 1,858 days. My submission is this, my lord, reasons given are not tenable because so my prayer is that, my lord, this may be the I may be dismissed at this.
Thank you. But actually, I'm saying that will not. That I may kindly be allowed, my lord, and very, my lord, that it may kindly be. Item amendment. And. Rashid, even the document shows that what are improved